जय हिंद। आज हम आपसे बात करेंगे इंफॉर्मेशन टेक्नोलॉजी एक्ट 2000। Dear friends, as you know that globally information technology was broadly established during 1990s, and roughly within 10 years India has introduced a full-fledged legal document named IT Act 2000. So what are the salient features? How it has been rolled out? What are the different stages of its development? We will see in little detail. So let's start. So we shall be discussing today few issues. Why separate law for information technology were required? What are the basic framework for these technology law? What are the salient features of IT Act and the amendment 2008? Information technology laws in other jurisdiction broadly, and a few case laws and certain exercises related. So few observations you must know, and this deliberation is mainly curated for the purpose of technocrats. That why technocrats must know law. We are dealing this topic today under the aegis of law with labs concept. So here, my dear friends, you please subscribe our channel so that you will get consistently the inputs, different topics, like for the legal students of law, maybe for LLB, maybe for LLM, or the legal expert, the professionals, maybe judges, prosecutors, the lawyers. On the other side, the technocrat. So this is a kind of interrelated, interdisciplinary approach. So that is my main concept under law with labs. So IT laws are not only dealing with civil liability or punishing guilt. It governs every system, platform, network and digital decision. My dear friends, why digital laws are important? Because we know that digital data is most precious. But that precious commodity is not in our hand. The data belongs to me or belongs to you, but that data is in the hands of someone else. So the owner of data is called data principal, and the person, the organization who has the possession of the data is called data fiduciary or intermediary. So our precious commodity is with somebody else. So how to protect that? That is actually deal with IT Act as well as data protection. So today we are going to take IT laws. Procedures are soul of justice since it ensures fairness. And you know about the role of fairness in the justice system. It is the seen part of justice. Justice should not only be done, it should be seen to be done. Justice is not only about truth, but about the fairness of its discovery. How the facts are being analyzed, how the truth is being explored. So that is very important, and as you know that digital data is invisible. So how the discipline can be maintained, how the trust can be ensured in different type of information technology, the digital transfers of messages, data and all, that is very much required. The substantive law promises justice, procedural law delivers it. Why IT laws were necessary globally? What was the need of information technology law? The traditional law meant for physical world. We were having our documents, books, newspaper, various other data in physical world. right? So we were keeping them in our lockers, maybe in our safe almiras. Instead, the digital data is invisible. It is moving very fast. So how to maintain the integrity of data, right? How it is in the safe hand. That is the important part, and that is why IT laws were in the system. As I said, in 1990, new emerging virtual world, virtual communication, but there was no regulation available at that point in time. We have introduced system of email, online banking, digital payments, but there was no legal response to borderless crime because data flow borderless. There is no India, no Pakistan, no Russia. Data can flow anywhere. But law has its limitation, the jurisdictional limitation. Indian law cannot be extended to any other country. Likewise, the other country law. So how to maintain that legal sanctity of such data transfer or informational technology per se? Electronic commerce explosion globally. You see, if there was no IT laws, then probably the e-commerce would not have flourished. E-commerce flourished because the law brought trust. Suppose if you buy something online, how can you trust until unless it is legally approved? So e-commerce was the byproduct of IT laws. IT laws gave them the validity, the trust in the public mind. That is why e-commerce these days, everything almost we are dependent on anything as a service, right? You are well aware. Then a new form of harms that was not recognized earlier, the hacking, the data theft, the privacy related issues. Nowadays we are very much aware about phishing, wishing, and digital arrest, sextortion. So these type of new crime do emerge. If there is no IT laws, there is no cyber laws, then how to deal with it? That is why these IT laws were very much important. So there was need for new definition of injury in digital space. Earlier injuries was in the physical space, like bodily injury, the reputational injury, the health injury, and things like that. Need for adequate procedural laws. Need for building trust. So the separate law were introduced in United Kingdom, Computer Misuse Act in 1990, Computer Fraud and Abuse Act of USA in 1996. The United Nations introduced UNICITRAL laws in 1996. It was a global template, and many of the laws were actually built up on this UNICITRAL global template. Like GDPR is also a global template for data protection. In Singapore, in 1998, Electronic Transaction Act was introduced, and of course, as I mentioned, India introduced Information Technology Act in 2000 and amended in 2008. Then European Union brought E-Commerce Directive, GDPR, in 2018. Now there are certain evolutionary phase. The first evolutionary phase, my dear friend, was the enablement. Enablement means enabling clause, like definitions, like other transactions, how to recognize electronic records. So document earlier were recognized as physical document, but with the advent of IT laws, electronic documents were also recognized. Digital records were also recognized as documents. Then the second phase was from 2000 onwards, the crime and security, because new crime start coming up in the digital space, like hacking, identity theft, e-fraud, and so on and so forth. So this was the second phase, crime and the security of the data. Then third was the governance. When the problem becomes wide, then there was need of governmental intervention, state intervention. That means the governance profiling started. The government take the corrective measures so that the public may not get affected by such cyber crimes. So this was 2010 to 2020. And now we are in the age of emerging technologies and their governance. So 2020 onwards, AI, big data, then cloud, digital sovereignty and all. So that becomes very important part. So evolving technology to governing technology, we are in the stage of from evolving technology to governing technology. So you just remember from 1990, it was enablement, that was evolving scenario, and now we are at the stage of governance, right? So code create capability, law create legitimacy. So it is the journey from technological code to legal code. Technological code means that act of technocrat. But that act can only be trusted when it is approved by the legal code. So technological code and legal code, they should have some synergy for building trust. Now, this is the framework of UNICITRAL. They have also almost the same framework because our laws were also based on the same platform. Legal recognition of electronic record and digital signature. In every IT law across globe, the recognition of digital document and signature is the most important introduction. Then technological neutral. IT laws, they do not regulate technology. Basically, they regulate function, they regulate application, they regulate misuse. So don't think that IT laws anyway impede your innovation. No, they support it. Basically, without legal support, technology will not be trusted. So, trust building can only be assigned if you have approval by the law. Then functional equivalence principle like physical world, authentication, integration, safeguard, for example, like hash value, that whether the sample is genuine. In physical world, you have chain of custody. Here, how the digital packet is identified, whether it is the same digital packet which was actually being procured. So it is identified by hash value. So hash value is identifier, like our Aadhaar card. Then jurisdictional cross-border recognition of electronic evidence. So electronic evidence get recognized across globe. It is not as if that the particular piece of electronic evidence is accepted in one court only, in one jurisdiction. No, they are pan-globe. Then predictability and legal certainty. These laws brought the predictability in behavior and legal certainty. Otherwise, if these laws are not there, then any conduct will not be certain because you don't know that what will be accepted, what not. So law give you certainty in your conduct and acceptability. So digital trade scaled because digital laws were harmonized. See, we without any fear, we actually go for e-commerce across globe. Why? Because these laws are operational. They are in practice. We have faith in them. We have trust. Otherwise, who is going to buy? And sometimes we get victimized because of fake IDs, fake platforms for e-commerce and all, because they are not certified platforms. Now, you develop your plan when you are dealing with IT laws, when you are actually doing some business, some product, manufacturing or design. Then you have to see the jurisdictional conflict, rapid technological change, diverse national priority and enforcement gap. These are the important areas. Now our IT Act. So here from we are learning about the salient feature of our Information Technology Act 2000 of India. So there are certain regulatory provisions for civil nature, for civil dispute, and there are certain penal provisions. My dear friends, in 2000, when we brought IT laws, not only in India, across globe, that time the issues were civil in nature, because the cyber crime were not very prominent, because those days the digital laws or digital use across globe were very limited. So there were disputes which were of civil nature, but slowly and gradually the digital space or our computers, our digital device, they were being used as target as well as medium. So digital space was used to commit crime, and that was also a target to commit crime. So medium and target both. Civil liabilities, if we see our IT Act, section 43 is mainly dealing with civil liabilities. So what kind of civil liabilities? There may be unauthorized access, data download without permission, then virus invasion, denial of service. So these are broadly civil matters. But if these activities are gross in nature, then section 43 may convert into crime, cyber crime. So they may fall under section 66, 67 to 73, 74. Okay. So this is a kind of transformation. As you know that for civil matters, the remedy is compensation, or the party can go for compromise. That is the nature of civil dispute. However, criminality, if we see, as I mentioned, that when civil matter under section 43 become criminal, so the act is done dishonestly or fraudulently. So let us again see that by fraudulent intention, by way of guilty mind, if you go for unauthorized access, if you are trying to download data with guilty mind, right, then it will fall under criminal act. Likewise, if virus invasion is ill-intended, right, or you are denying service to harm the person criminally, right, then it will be criminal liability, and there will be punishment up to 3 years or fine up to 5 lakh. The example, best example under section 43 is stealing the data by the employee. This is a very, very gross problem across various cities. Now, section 66 is basically dealing with cyber offenses. What are those cyber offenses? 66C deal with identity theft, then 66D deal with online cheating. You remember long back in 2013-14, one case, Shreya Singhal versus State of Maharashtra, when Shiv Sena chief Shri Bal Thackeray ji died, he died, and there was some Bandh declared by the follower of Shiv Sena. The two girls, they were just chatting, talking something, that why this Bandh and all, and Maharashtra police slapped an FIR against those girls, and they were arrested. And the matter was dealt by Honorable Supreme Court, and court found that section 6 is actually unconstitutional, and that is why it was abridged. So 66 was actually abrogated by way of case named Shreya Singhal versus State of Maharashtra. Now, there are other sections, as I mentioned. Section 66 has other part, section 66F, that is cyber terrorism. 72 and 72A they deal with breach of confidentiality and privacy. Right to privacy, my dear friend, become very sacrosanct, and India is the only country which has declared right to privacy as fundamental right in 2017 by way of K.S. Puttaswamy judgment. That is very prominent case. We will deal this case sometime. Section 70B establish certain. Certain is the regulatory mechanism. We will talk about how regulatory bodies are very important in technology matter. Most of the time, the technology related matters do not go to High Court or Supreme Court. They are dealt by regulatory bodies. Regulatory bodies are actually specialized bodies because technology is very much you can say knowledge centric. They have technological know-hows. So a general disciplined judge who has vast knowledge but may not be sound in technological complexities. That is why regulatory bodies are getting more and more prominence in technological matters. Every technocrat must endure, that is very important for the technocrat to know, the access control and authentication. They must secure logging and audit trail. They must know how to respond to the incident. There must be data minimization. Data minimization means that you should not collect data unnecessarily. Data minimization. Then timely breach reporting. Then content modernization, legal awareness. Every technocrat is a potential compliance officer. So technocrat must know the law. That's the point I want to make to all the technocrats, irrespective of their positions. What is the role of certain? Certain, as I mentioned, was established by way of Section 70B of IT Act. Certain is a regulatory body which is responsible for collection, analysis and dissemination of cyber incident, issuing alert and advisories. They coordinate response to cyber incident, calling information from service provider and organization. They issue binding directions. So that is a regulatory body. They are ombudsmen. They are watchdog. So these regulators have very important role in dissemination of justice. So certain is not advisory only, it is regulatory authority with enforcement power. Enforcement means that if you do not abide those regulations, then you will be penalized. Safe harbor. We will be discussing safe harbor sometime in detail, but safe harbor is a very important clause. My dear friends, safe harbor gives you a kind of immunity, a protection to the platform, to the architect, where if somebody publishes as third party on any platform, any material which is maybe illegal, causing harm, then the responsibility of the platform may not be there if they follow certain guidelines, certain principles. So how it was evolved, it is a very important thing. As I mentioned that IT laws developed in year 1990s, or you can say in that decade, in 1990s. So see, the legal issue was that online platform, whether they should be treated like a publisher, say newspaper. If there is a news in the newspaper, whether newspaper should be held responsible or not. Of course, in newspaper, if a news is being published, newspaper is responsible because it is a publisher. But whether platform is a publisher or not, this was a legal question. Understand it again. Say for example, on WhatsApp, it is a platform. If you publish something which cause harm to the society, so whether the WhatsApp company is liable for publishing any harmful material by third party where there is no connivance, then what is the liability of the platform? This was the question. It was dealt by the Supreme Court of United States in two cases. One was in 1991, Kabi versus Kopu-Serve. In this case, Honorable Supreme Court held the platform liable, like publisher. They said that if anybody publish anything which is harmful on your platform, you will be liable. So that was the point. It creates a lot of, hue and cry, because social platform, how can you control? You may not be having connivance, but somebody, because say for example on WhatsApp, on Facebook, on LinkedIn, there are so many platforms. If you write something harmful, how can you be controlled and how can the platform be liable? So this question was raised. So that order was reversed in 1995 in Starton Oakmont versus Prodigy. In this case, they held that platform may or may not be liable. So there were conditions that if there is a connivance of the platform, then only they will be held liable, right? So prevailing message become clear: do not moderate content. If you have not moderate content, if you do not have any connivance, if you have reported the matter timely, then your liability won't be there. So US Congress passed an statute. That is very important. Having seen these developments in the court of law, that a platform should be considered as a publishing platform or not. So the US government, US Congress brought section 230 in Communication Decency Act of 1996. They consider platform not as a publisher. So ultimately the Starton case was formulated as statute. What was the name of the statute? The Communication Decency Act of 1996, where section 230 says that platform is not a publisher. It means that in United States, publication of harmful material on digital platform is not held liable to the platform. That means platform got almost absolute immunity, and that is the reason why most of these controversial, harmful content are being published on those platforms which are situated in United States, or like those countries which have the safe harbor clause by and large absolute. Safe harbor in our India under IT Act of 2000, section 79. 79 is a very important section. The condition in India is that immunity to the intermediary has certain conditionalities. It is not absolute like in US. It is conditional immunity. So what are those conditions? That it should initiate the transmission, but it should not have any participation. It should not have any moderation. It should not have any kind of hand and gloves. So if there is no such type of participation in publishing such harmful content, then there will be immunity. Section 79, subsection 2, part C says the intermediary observe due diligence. So due diligence is the buzz line in India, and certainly the court has also intervened in a different manner, and they say that our platform should be more responsible towards the society so that there should be no social harm. So due diligence is very important. So in our country we have responsive immunity, concept of responsive immunity. Indian jurisprudence thus steadily narrow the gap between safe harbor and social accountability. So there is a balance between safe harbor and social accountability. Court judgment, there are certain court judgment in India. First was State of Tamil Nadu versus Suhas Katti, the first Indian cyber case prosecuted. This was the first case of cyber crime where the accused was prosecuted in 2004. Then second case was CBI versus Areem Azim, that is Sony Sambandh case. In this case, actually, Sony introduced one policy or one offer that if someone is purchasing to gift someone in India, outside the country, outside India, so they will give some rebate or something. So Areem Azim, he actually stole the data of someone ATM data, and he used that data, or rather he misused the data of ATM, the password and others, and he purchased some valuables in India. When the bill was raised to the party in United States who was the owner of ATM, he said that no, I have not purchased anything, and the case was slapped against Sony Sambandh matter, right? The case was given to CBI because it was a very complex case at that point in time, and ultimately the culprit Areem Azim was arrested. The other case was Shreya Singhal, I have already talked, where section 66 was abrogated. In Sabu Mathi George case, you might be aware that there are so many online platforms which provide the facility of sex selection, that is called amniocentesis. So the court in Sabu Matthew George case says that it is the responsibility of the platform not to publish such illegal material for sex selection of the embryo and all. So they actually implicate or punish the platform. So learning here is search engine must proactively block illegal content. So that is most important. We are just a platform, is no defense, where harm is predictable. So you must be observing due diligence. That's the learning point here. Another important case was Avnish Bajaj versus State. This is a very famous case of Baji.com, where Delhi Public School MMS, if you remember, I have also done one reel on that. So here the CEO, Mr. Avnish Bajaj, was sent to jail by Delhi High Court, although subsequently the Supreme Court intervened and the CEO was released, but it actually led to introduce the IT Act Amendment of 2008. So Baji.com is again a very important judgment in India, where High Court Delhi has punished the CEO for publishing the obscene MMS of a girl from DPS school, Delhi Public School of Delhi. Then court on its motion versus State NCT Delhi of 2024, again the same thing. The court said that if any child pornography is being published on any platform, it is the liability of the platform to not to publish such illegal material. Then Parajwala versus Union of India. This case was in 2024, again related with the child sexual abuse material to be published on online platform. The court again says that the platform should take proactive action. They should observe due diligence and they should immediately remove such pornographic child sexual abuse material. So what are the takeaways? Logs are the new legal witness. So the logs are like legal witnesses. They cannot tell lie until unless they are being manipulated. So I generally say that in digital world, you can say like, तू जहाँ जहाँ चलेगा मेरा साया साथ होगा. So whatever you do in digital space, they get logged, and that log are your footprint, and they are saved, they are secured forever. So whatever you do in digital space, please be very careful, cautious and legal. The compliance is not a paperwork, it is an architect. We will be talking about Article 25, that how safety by design, legality by design, privacy by design. These are the three buzzwords of Article 25 of GDPR. Then IT laws build design trust. Without IT law, you cannot build design trust. Then cyber security is a statutory duty, as I told in Article 25 of GDPR. We will take it up slowly and gradually before you, that legality by design, privacy by design and security by design. So my dear friends, at the last I will say design safety or defend legally. So as a technocrat, you must design your product safely. They should be safe from the design. The future belongs to compliance ready technocrats. So it is a duty. All the technology institute like IITs, IIITs, MNRs, NITs and all. Of course my own institute like UPSIFS. All should comply the legal format. We should teach our young technocrat in BTech and FTech that how the necessity of legal compliance is necessary in your technological work. So that is our USP. जुड़े रहिए हमारे साथ, सब्सक्राइब करिए हमारे चैनल डॉक्टर जी के गोस्वामी IPS को, that is my request, and share the channel and give your comment. Thank you very much. Stay safe, enjoy the day. Bye.